It's good to hear that the government has begun to take seriously the problem of the integrity of the border, particularly with respect to illegal, or if you prefer, irregular border crossers, such as we have experienced at Roxham Road in Quebec. Unfortunately, while the government is making noises that it wants to repair the damage at the border, there is little evidence that the measures proposed will be effective, and the government has not yet committed itself to changing the rules so as not to reward people trying to game the system or to penalize those trying to obey the law. This video is based on the testimony I gave to the Parliamentary Committee studying the government's new legislation on strengthening the border. Let me begin by explaining the problem at the border. Canada's highly successful post-war immigration policy, supported by an all-party political consensus and by public opinion, has never been laissez-faire about who gets into the country. On the contrary, that admirable policy has always been premised on the idea that Canada decides who gets into the country and that the selection process be carried out in a disciplined and orderly way. In the last several years, however, that supportive public consensus has been seriously undermined. First was the discovery that would-be immigrants could exploit a flaw in the law regarding people wishing to claim refugee status in Canada. The current law is premised on the sensible notion that refugees should make their claim for status in the first safe country they arrive in. Indeed, the priority with refugees is their safety, not their ability to shop around for the country they would most like to live in. Since the bulk of refugee claimants arriving in Canada did so via the United States, we negotiated a safe third country agreement with Washington. It ensured that refugee claimants attempting to enter Canada from the United States would be turned back on the grounds that the U.S. is a country with a sound process for assessing refugee claims. Some clever person worked out that this rule could be avoided simply by crossing the border illegally, since there exists no mechanism under the Safe Third Country Agreement for returning refugee claimants who enter elsewhere than at official border crossings. Once this unintended loophole became public, the predictable result was that tens of thousands of people crossed the border illegally and presented themselves as refugees, when in fact a great many of them were simply queue-jumping economic migrants. Indeed, fewer than half of these refugee claimants have had their claims accepted. The government's first response to criticism questioning the wisdom of this policy was to accuse its critics of racism and wanting Canada to abandon its commitment to the fair treatment of refugees. This was untenable on several grounds. First, many of the critics were themselves new Canadians, understandably upset at a weakening of the integrity of an immigration system which many of them had patiently navigated to come to Canada. They felt the law-abiding were being penalized and queue jumpers given an unfair advantage. Second, it logically implied that the current official government policy that turned refugee claimants back at official border crossings was also racist and failed to uphold Canada's refugee commitments, which was clearly nonsense. Alarmed at the erosion in public confidence in the immigration system, the government is now trying to project an image of stern defender of the border, but so far it is regrettably largely image over substance. One measure proposed by the government would make ineligible for refugee status claimants who have previously made a claim for refugee protection in a third country, like the US, the UK, Australia, or New Zealand. It's meant to stop cases of so-called asylum shopping, which is when asylum seekers make claims in more than one country. Such behavior can cause stress on our overloaded asylum system, which we should recall has a backlog of tens of thousands of people. However, it appears that these changes simply move these claimants into a different bureaucratic process, which still would not result in their removal. This measure seems in large part window dressing, not least because the changes will affect perhaps 10% of irregular migrants, according to Minister Blair, the minister responsible. By contrast, a very positive step the government is taking would amend the Immigration and Refugee Protection Act to provide real consequences for countries that obstruct our efforts to return their citizens that we are attempting to deport. Specifically, we may deny or suspend applications from those countries for temporary resident visas, for work permits, or for study permits. This is a reasonable and pragmatic action to enforce reciprocity with otherwise uncooperative countries and ultimately to expedite the removal of deportees. It's a measure that we have recommended at the Macdonald-Laurier Institute. It is a change that could make a real difference and lead to better immigration enforcement results. Leading an international effort by like-minded countries to generalize this approach would allow Canada to exercise genuine leadership in the field. In fact, we should take this farther. We should enlarge the scope of the sanctions we can employ against non-cooperating countries, including all visas, development aid, the operation of any trade agreements, and any other means of bringing pressure to bear. We are spending ever more resources on deporting ever fewer people because countries don't want these people back. We cannot allow these countries to exploit our generosity, which will only lessen the welcome we can extend to genuine refugees. The heated objections from the refugee industry and the Immigration Lawyers Club to these changes are hugely overdone. To those who might accuse the government of abandoning its commitment to fair treatment of refugees, the head of the UN Refugee Agency in Canada himself says the changes are, and I quote, "no cause for alarm." The other step Ottawa has announced is an opening of talks with Washington aimed at changing the Safe Third Country Agreement so that the US must take back refugee claimants no matter where they enter Canada from the United States. Reportedly, this will entail Canada bringing these claimants to an official border post where they will be returned to officials of the United States. Amending the Safe Third Country Agreement to close the loophole would be a real step in the direction of restoring the integrity of our immigration system. Unfortunately, Washington's motivation to help out in amending the STCA is low, although that may be changing as the numbers of people entering the US illegally from Canada is rapidly increasing, a vital but little noticed fact here in Canada. Projected talks are a handy election talking point, but we are still far from fixing the damage that has been done to the integrity of the border, especially since the various recent government plans to increase enforcement and other capacities at the border are largely gathering dust. Canada would be right to tighten its borders. So far, it has failed to do so. I'm Brian Lee Crowley for the Macdonald-Laurier Institute.